My name is Roger Clark, and welcome to this episode of the Fourscore Project, a production of the New Majority Foundation. We're a public charity that strives to educate the American people on the important issues of our day by exploring all angles of these issues. Ultimately, we seek resolutions that are common sense in nature and preserve and protect representative democracy in a way that respects the dignity of all Americans. Today, our subject is public safety, and we're very fortunate to have with us a person who's the best suited to address this issue, Steve Cooley. Steve, welcome.
Well, thank you, Roger.
Steve, if you will bear with me for just one moment, let me just remind our audience that you have a tremendous background in public safety. You have been a reserve police officer for many decades. You came from a crime-fighting family. I believe your father was in the FBI, and you were the district attorney for the County of Los Angeles for 3 consecutive elected terms. And in fact, I think that puts you in pretty hallowed ground in all of the history of Los Angeles over the last 175 years. I think there's only 2 others that were elected to 3 terms. And the last 2 were maybe 100 years ago, so it's been quite a while. And also want to point out that you chose not to run for a 4th term. Hopefully I got that right.
You got everything right. I was a reserve officer from 1972 through 1978, so not decades, but a good 7 years working LAPD, Newton Division Patrol. My father was an FBI agent. He retired in 1955 after joining just before World War II. He loved the Bureau and his job within that organization. I was actually with the DA's office for 4 decades. And as you mentioned, 3 terms, 12 years as the elected DA, which is in recent history the longest serving DA in Los Angeles County, having served 3 consecutive terms.
Well, you know this issue of public safety better than any of us. And let's just kind of jump right off. One thing that I always think is important is let's get our terms defined. So when we say public safety, let's give a definition to that. Public safety to you would be what, sir?
Well, public safety can be measured, of course, by certain statistics that measure crime and various forms of crime in our society. The most accurate statistic are those prepared by the FBI, and murder rates are the most accurate of all the statistics maintained by any law enforcement agency throughout the United States. So that's one benchmark. But there are other ways to measure public safety, and that is the lesser crimes. And the phenomenon could be drug dealing, it could be fentanyl deaths in contemporary society. It could be new forms of crime, such as the current forms of theft that are occurring in society, which are kind of new and different. So, and public safety is also a sense of the public. How do they feel when they get on a Metrolink train, or they're downtown Los Angeles, or they're going shopping late at night, or they're coming home from work? How do they feel? Mm-hmm. That's one way to measure public safety, is how the public feels. And so I think you can look at public safety from all sorts of different angles. And the way you achieve public safety is good laws and good people enforcing them. Those are the 2 major components of the equation. If you have good laws and lousy people enforcing them, whether it be law enforcement officers or the district attorney or a city prosecutor, it's not going to work. If you have bad laws, as no matter how good your law enforcement agencies are or your prosecutors are, it's not going to work. And right now, in some instances, we don't have particularly good laws because of our state legislature and their view of the world. They're sort of decimating and denigrating what was a pretty good system that achieved the lowest crime rates in 60 years. And then you have, in some instances, very poor people in charge of enforcing the laws.
Well, I want to come back in just a minute because that's a fascinating dichotomy you made. You need two things, the good laws, and you need the right people to enforce those laws. I do want to come back and revisit that shortly. But you also said the component of public safety is also the perception that the general public has of how safe they are. And an unscientific survey by myself, talking to people that are my friends, people I run into, and I don't think I'm an outlier on this, it seems to be an overwhelming sense that we are not safe. Is that something you would agree or disagree with?
You're not an outlier. I think the public at large does not feel safe, and they, I think more so now than ever, calculate where their children are going to be, their spouses, their relatives, and they think through, well, is that going to be safe for them? There are many areas within Los Angeles County that historically have been perceived as being safe. Well, they aren't as safe as they used to be. There's a lot of home invasion robberies, a lot of burglaries, high-end burglaries in some of the wealthier enclaves. Those areas, they may have perceived themselves as being safe. They aren't safe because I think the criminal element feels more emboldened, more confident, and they are more aggressive nowadays. And then, of course, we read about the crimes, we see them on television, and because of video capacity and the ever-present nature of video cameras and people on their cell phones, and I think that adds an element of fear for the average person because they see it and they go, well, that can happen to me.
Well, we're sitting here in Los Angeles, and this issue of public safety and the increasing perception of the public that they're no longer safe is a national issue, of course, but the places that get the most attention are the big cities, in particular New York, Chicago, San Francisco, and L.A. Is the public safety more at risk in those particular cities than other parts of the United States, or is that just a misperception?
Well, first of all, there are many other cities where things are out of control that I could name. There's probably several, particularly where there are district attorneys who are, we call them Soros-elected district attorneys. Right. In those cities, markedly, and in a very documented way, things are less safe. It could be Milwaukee, could be St. Louis. There are Portland, a mess. Seattle's a mess. San Francisco is not even a large city. It's only got 700,000 people, but it's sort of a mess across the board, from very aggravated theft issues, open air drug dealing, open air drug use, auto burglaries. It seems to be almost in a world of its own. Now, Los Angeles, people look at, well, the city. Well, I look at Los Angeles as the county. There's 4.2 million people in this city, and this city is very diverse in terms of socioeconomic factors. But remember, there's 87 other cities in Los Angeles County, and each one has their own, let's say, challenges when it comes to crime. Lancaster, Palmdale up in the Antelope Valley, that's different than down in Long Beach. LA County is so diverse that you get to look at the problems and the challenges in certain regions and in certain cities.
Well, it's fascinating because the district attorney of Los Angeles is not the district attorney of only the city of Los Angeles, but is the district attorney of the county, which includes not only the city of, but the 80 other cities plus the unincorporated area.
Well, the way it works is 10 of those cities have elected to have their own city prosecutor. And they range from the city of Los Angeles, which is very large, to medium-sized cities such as Burbank and Torrance. Long Beach has their own city prosecutor, and then some smaller cities who have their own city prosecutor. But the other 78 cities rely upon the district attorney to enforce their misdemeanors and to prosecute their misdemeanors. Mm-hmm. And then you have large areas unincorporated within Los Angeles County, misdemeanors there are prosecuted by the district attorney. And of course, felonies throughout the entire county are the exclusive jurisdiction of the district attorney.
For the people who are watching, a couple of terms that you mentioned, which come out of your Bible, law enforcement Bible, probably the day you were in law school, but misdemeanors and felonies.
Right.
Tell the viewers what the difference is between the two.
Well, historically, crimes that could merit a state prison sentence were deemed felonies within the California Penal Code. Crimes where the sentence was up to 1 year, but not to exceed 1 year in the county jail, and where the punishment would occur in a county jail setting, those were deemed misdemeanors. Now, since AB 109, one of the legislative disasters of our time, has taken place as a little bit of a hybrid there. Now, only those crimes that are serious or violent result in actual housing in a state prison setting, those felonies. All other felonies that are not sex, not violent, not serious, when they are sentenced to custody by a Superior Court judge on a felony, their incarceration is handled by the county at the county level. This is a great departure by the state legislature, led by Jerry Brown and others, to reduce the state prison population, which was an issue, and to shift the burden of incarceration to the counties when it comes to a great number of felonies where judges have decided, I am going to sentence this person to a state prison sentence. Okay, fine. Except that state prison sentence, by law, must be served in a county facility, which really burdens the counties, by the way.
And AB 109 is a piece of legislation coming out of Sacramento, and I'm also going to talk to you about 47 and I believe 57.
Oh, yeah, that's the triumvirate.
That is the triumvirate, I believe. And but 109. So now there's a distinction between a rough distinction between violent felonies and non-violent, and I suspect there's a lot of disagreement over what constitutes violent.
Well, they're defined. Violent and serious felonies are defined by certain sections in the penal code. They are very well defined. There's some overlap between those defined as violent felonies and those described and listed as serious felonies, but they're defined very specifically in the penal code. And then everything else is not violent or not serious, just by a process of elimination.
So if we focus on nonviolent felonies, the time can be served in a county jail as opposed to a prison. And I sense from your comments that there's something lacking in serving time in a county jail when it should be served in a state prison. That's the sense I'm getting. Can you explain a little bit about what the differences are between a state prison versus a county jail?
State prisons historically were designed for individuals who were committed to longer terms in a facility, an incarceration facility. County jails were designed really as a place for pretrial detainees, people awaiting trial, and then individuals who have been sentenced to relatively short sentences at the county level. That essentially is the distinction.
So someone with a nonviolent felony under AB 109 could serve 10 to 15 or more years in a county jail as opposed to a prison?
Theoretically, that's possible. I am aware of one particular case where a judge, following the law, sentenced to someone to 44 years, but it wasn't for a serious or a violent felony, and that person will have to do his 44 years, or at least some portion thereof, in a county jail facility. County jails were not built for long-term housing of criminals. They were built for short terms of punishment, not to exceed 1 year,
right,
and for pretrial detainees. There are hundreds and hundreds of individuals in our LA County jail system who are awaiting trial, who are pretrial detainees because they can't make bail or they're denied bail. They are the murderers. They are the robbers. They are the serial rapists. They are the big-time drug dealers. Those are the people that are pretrial detainees awaiting their trials, and they're kept in these in a county jail facility, which is for shorter term.
I know in an ideal world, someone goes into the system, whether it be prison or county jail, and we ideally would like for them to be rehabilitated, go out, live productive lives, never commit another crime, never come back into the system. Is there a difference in terms of this term recidivism between those who serve their time in a county jail versus those who serve their time in a prison?
I don't know if there's really a difference in recidivism between those that come out of prison on parole or those that come out of county jail on parole, because the parole rules have changed so much that it's hard to even compare the current rate of recidivism to what it used to be, which used to be defined by, do you run afoul of the law within 3 years of being released from the facility? I don't even think those statistics exist nowadays. The key, though, is the purpose of the penal system is stated in the penal code. It is to punish. And also, it is stated in California law, it is to rehabilitate. They call it the Department of Corrections and Rehabilitation. So it's the obligation of the state to provide.
And this is for prisons.
Yeah, for prison. For those individuals who are committed to prison, who are going to eventually get out, to provide some sort of the programs that would allow for them to be rehabilitated. So they can emerge from that period of their life and be contributing citizens. And that's an obligation of the state that I don't think the state's been particularly good at historically. And they only started focusing, I think, on it as a matter of law when Governor Schwarzenegger was in office. That's when they changed the name, they changed the focus from not just punishment, but to include rehabilitation.
Rehabilitation is a goal, whether it's been effective or not, as compared to the county jails, which is not charged with rehabilitation.
It's not a basic mission, and oftentimes a person is in a county jail for such a relatively short period of time that a longer term program for rehabilitation, the opportunity just isn't there the way it is in a state prison setting.
When I was in law school and I took my criminal law and criminal procedure classes in my first year penance that all law students do, I remember that deterrence is also part of the criminal justice system. Any thoughts on whether the threat of serving prison time or county jail time as a deterrence is actually effective?
But you're totally right. Deterrence is the other main objective of the criminal justice system, is to deter an individual from repeating the crime by punishing that individual, and to deter others from committing that crime by looking at the person who's been caught and being punished. So deterrence has always been a consistent goal of any penal system. Now, are people deterred? I think they are. If they look at someone in their neighborhood going away to prison for an armed robbery, they may think, you know what, I'm going to do something else other than commit armed robberies to make a living. I think there is, and historically always has been, a deterrence of individuals from committing crime if indeed the system is capturing them in a timely manner after the crime and punishing them appropriately for the crimes they've committed and their criminal history. So I do think that it can be achieved, and it is achieved, if the laws are enforced, if people are arrested, if people are truly incarcerated for their crimes and their criminal history.
Crime obviously has been around, it seems, forever, since there have been human beings. My sense, though, is that the rate of crime over the past, I'm going to ask you this, a certain period of time has suddenly begun to grow exponentially, or certainly at a higher rate than it once was. Is that perception accurate?
It's accurate. Back in the mid-70s, early 80s, crime was at an almost all-time high. Here in Los Angeles County, throughout California, pretty much throughout the United States of America. But back then, states like California responded with a high crime rate and the historic lack of appropriate punishment by changing the law from the indeterminate sentence law to a determinate sentence law. And sentences over time increased in terms of time. State prisons were built over time to house this new influx. And we went from one of the highest crime rates in recent history.
We're talking about California?
California and LA County. Highest crime rates, certainly in our lifetimes. In the late 70s, early 80s, until the early 2000s, when the determinate sentence law had been around since 1977. Crime rates were at a 60-year low. They had not been that low since the mid-1950s.
Now, what year are you talking about when they were so low?
Between 2000 and about 2012. And then it kind of just started creeping back up. It crept back up because AB 109, and then Prop 47, and then Prop 57. All these things sort of came together to diminish society's efforts to deal with the criminal element and incarcerate them appropriately. And now we're seeing an increase in crime. We're going back to the high crime era of the late 70s and early 80s, and we've abandoned the very low crime era that existed basically 2000 to 2012 or so. That era, lowest crime rate in 60 years. It was a really good period for the law-abiding public and public safety.
Let me ask you to define another term, or terms that you just referred to. I don't want to let that go under the bridge without addressing it. You said determinate and indeterminate sentences.
Yes.
So what's the difference between those two?
Okay, historically, California was what they called an ISL, an indeterminate sentence law state. Essentially, someone would be committed to state prison. You probably heard the term on television, for the term prescribed by law: robbery, 5 to life, attempted murder, 10 to life. But they would go in, and then, based upon their evaluation as to when they had been quote-unquote rehabilitated, they would then be released. Oftentimes, in a relatively short number of years. The 5 to life sentence might be 2 years. A second-degree murder might be 5, 6, 7 years. The sentences in the indeterminate sentence law were relatively low. And it's not because people were really being rehabilitated. It's just that the state prison had a capacity, and so they were being let out to manage the people sentenced to the state prison within their existing facilities. And it was then that finally great leaders like George Deckmajian and then subsequently Pete Wilson went to work and built the prisons to accommodate people who were being sentenced under the new law, which became effective in July 1977, which was the determinate sentence law. And initially, DSL, as it was called, determinate sentence law, had relatively short sentences because they had to reflect the average sentences for people that had been committed under the indeterminate sentence law. Right. But once it was in place, once that structure was in place, the legislature and the people, by way of initiative, increased the sentences and the potential time and the ways you could get more time. Prior convictions, use of dangerous and deadly weapons, infliction of great bodily injury, excessive taking or damage. All these enhancements were added that, if proven, could add more time to a person's sentence based upon the nature of the crime or the criminal history of the criminal.
Let me ask you about prisons. When's the last time we constructed a new prison in the state of California?
I don't think we've constructed a new prison in California for probably, I'm going to say 20 years. Maybe, well, I think it was probably under Governor Wilson. And he and George Digmagian and the public at large who had voted to build those prisons and fund those prisons, fund the construction of those prisons, did greatly expand the prison capacity. But even that capacity got to the point where there were challenges to whether or not it was cruel and inhuman, unconstitutional.
You're referring to the federal court decision.
Yes, the Supreme Court
about
decision.
2006, 2007, somewhere in that time frame.
And they said, look, it's really a little too crowded there, California. So the crime rate was really low. It was a product of that era of incarceration. There had to be something to reduce the prison population. And there were different ideas proposed, some of them actually pretty rational, and some of them reckless.
Because I took a look at that decision a couple of days ago, and I may be off a few thousand here or there, but I believe that the prison population, not the jail, but the prison population in California was up to about 179, 180,000, somewhere in that range.
You're right in the button in terms of the
somewhere.
numbers, yeah.
But yet the prison capacity was built for something around 100 to 110,000.
Right.
And the federal court said, cruel and unusual, it's
right.
You need to drop it.
They basically measured the actual number of people in prison with what they called designed bed capacity. How many beds do you have for the people that are in there in terms of normal incarceration in a cell, called designed bed capacity? And the number of people in the state prisons vastly exceeded designed bed capacity, leading to the Supreme Court's decision. And the response could have been, okay, let's figure out how we're going to adjust the sentences and let certain people out who are less risk, less violent, or the alternative, build other incarceration facilities, maybe some less expensive than some of the state prisons, but for the nonviolent, non-serious incarcerated person. But then California took a wholly different approach than some of the more rational approaches to reducing the prison population.
Well, it seems to me the reason I'm kind of pursuing, this line of questioning is that if the rate of crime is increasing, that certainly is an important factor, but the rate of population in California traditionally has increased as well. So it seems that even if your crime rate is stable, with more people every year, you're going to have an increase in crime. And if you're not building new prisons, the net result seems to be an overcrowding of the prison system.
Okay. I've always said that the crime rates depend upon whether or not people that should be in are out. And the object of the system is to determine who should be in and for how long.
Right. And
that if you do a good job of figuring out who the true recidivist, violent, dangerous, repetitive criminals are, and you incarcerate them, then your crime rate's going to go down, no matter what your population. You have to make sure that the people who should be in are in. And we have clear examples, I'd like to say almost daily, but maybe not, maybe that's an exaggeration. We have clear examples of innocent people being victimized because a person who should have been in was out. I'm talking about police officers who were murdered. You look at the person who killed him. He should have been in by law, but someone screwed up. Someone did not follow the law. Someone did not make sure that they got the appropriate sentence. 2 officers in El Monte went out to resolve a dispute, essentially a domestic type dispute, and they were both killed, murdered by someone who was supposed to be in. Sergeant Boyer, Whittier police officer, he responds to a traffic accident, routine, and the gang member who was from East LA who had killed his uncle a few hours earlier and stolen his car decides he doesn't want to get arrested for stealing the car and killing his uncle, so he just kills Officer Boyer. You look at his history, he should have been in. He was in violation of parole. He should have been in. He was out. And that's what happens. People that should be in are out. And then who gets hurt? Law-abiding public.
Well, in that example, in that example, so you have this gang member that has a record, had obviously been sentenced for prior crimes, violated his parole by committing further crimes, but yet he's out. So then he commits murders.
Right.
When he should be in. Whose fault is that? Is that the judicial system?
Sometimes it is the parole authorities who have not detected someone. Sometimes it's the law. In the case of Sergeant Boyer, it was AB 109 that had wiped out normal parole and substituted some kind of a weird, they call it flash incarceration by the probation department, and that failed. So in that case, it was the law that failed. In other cases, it's the district attorney who is not achieving an appropriate sentence according to the law. The 2 El Monte police officers who were killed, that person should have been in state prison. It was easy. It was not complicated. He was charged with ex-con with a gun. He had prior strikes. He mandatorily should have been in prison. But the district attorney had a policy, we don't file strikes. Therefore, you lose the power of putting him in prison. Mm-hmm. He gets a sweetheart deal. He's out in 20 days, and he kills 2 cops. It's an easy thing to figure out when you look at why the person is where he is. Mm-hmm. Well, he was out, and he should have been in.
AB 109, though, I think you just defined that as falling into the category of a not good law, a bad law.
That's one of several.
One of them, and because of the defects in that particular law, this gangbanger was out and was had the opportunity to kill innocent folks.
Right.
What was it again about AB 109 that allowed him to fall through the cracks and still commit these crimes?
AB 109 greatly reduced parole as a way to deal with the criminal element who had been in prison and were out. It basically reduced the ranks of parole officers substantially and placed many of those burdens on the local probation departments, who were really not equipped to deal with that sort of criminal. And then they substituted a system of when you violate parole, you go back to prison for up to a year. They substituted with a system called flash incarceration, which is if you violate the terms of your parole, we're going to call you in and have you do 10 days and see if that gets your attention. Well, that's not very much time to be in. And secondly, for a hardened criminal, it's not much of a deterrence. And in that particular instance, under the old system, he would have been in violation of parole. He would have been back in state prison. But around that same time, the new system had come in, AB 109, and he was out when he should have been in.
Well, coming back to the trilogy, and I do want to ask you specifically about AB, or not AB, but 47 and 57, in addition to AB 109. To me, it seems that these laws all seem to be some reaction to dealing with a federal court decision that ordered a reduction of population of the prison. We can come back and talk about that, whether that's an accurate observation or not. But let me come back to an even more basic question is, what's your explanation of how we got in a situation where we had a significant overpopulation of our prison capacity? How did we get into that spot that led to this federal court decision?
Okay, the question is, how do we get in a position where we had an overpopulation leading to a Supreme Court decision sort of saying reduce your population?
Yes.
It's a very good question. One, we did not build more prisons when we could have. That would have been an option. Mm-hmm. And two, the ways that the state government chose to deal with the overpopulation was through AB 109 and then subsequently Prop 57. 47 is sort of a different animal, but was to basically reduce the terms, the amount of time someone was in and where they were in. That's how they dealt with it. And right now, the state prison population is so low, they're closing prisons, which they could use to house a few of these guys. But so that's really was a problem. They didn't use other ways that were logical that they could have reduced the prison population to accommodate the U.S. Supreme Court sort of saying you're overcrowded to the extent it violates the Eighth Amendment. They didn't go that way. They went AB 109, which just sort of said, hey, we the state, historically we've housed people in state prison. When they're sentenced to state prison, but we're going to change that. Now, if a judge sentences someone to state prison, and it's a nonviolent, non-serious, non-sex offense, you, the counties, are going to have to take care of that state prison commitment at your local level. Well, that certainly reduced the number of people in state prison and has had a dramatic effect over time to reduce the number of people in state prison. So if a Superior Court judge says, I'm sentencing you to state prison for 8 years. Oh, if it's nonviolent, non-serious, non-sex, guess what? You get to go to the local county jail for your sentence. That's how the state got away from that historic responsibility.
There may be people watching that are asking themselves if the prison population in California is dropping to such a low level and we're actually closing prisons, but yet since 2012 we've had an explosion of crime, which just those two statements in their own seem to be in tension with one another. But I think you just gave an explanation. I want to make sure that we understand each other on that point. Why are we closing prisons and reducing prison population, but yet we have an explosive growth in crime? Is that due to the 109 and other laws that California has passed?
It's I think the two major legal laws are AB 109, shifting the housing responsibility for people sentenced to state prison for nonviolent, non-serious, non-sex offenses, having them housed in a county jail setting. That reduced the population significantly. Prop 57 also made individuals eligible for parole much earlier than they would have been under the historic determinant sentence law. So they only had to serve actually a relatively small amount of any term, no matter how long, before they're eligible for parole. So many of these people get paroled a lot earlier. Now, throw Prop 47 into it, that sort of changed the whole configuration of the theft laws, but it also reduced all hard drugs from being felonies to being misdemeanors.
Possession.
Yeah, possession.
Right.
Not sales,
right.
Not possession for sale, but possession of hard drugs are reduced to misdemeanors. So now you have either minimal or no enforcement of the laws when it comes to simple possession of drugs, which when you control the drug abusing criminal element, by enforcing drug laws, you're also impacting burglaries, theft offenses, robberies, and other crimes. But that was all taken away by Prop 47. I'm sure you've seen the incredible explosion in essentially theft, retail theft, including mobs going in and stealing items, individuals crashing into stores with their stolen cars and stealing items, people's going in and clearing out the shelves of high-end beauty products and walking out. That's something new and novel, and it's frightening. If you're a customer at Nordstrom's, you don't want to see 30 or 40 thugs coming in and taking things off the shelves
And not being stopped.
and not being stopped on the way out,
Yeah.
and or not being prosecuted effectively by the local prosecutor.
47. Changed drug possession from felony to misdemeanor. Is that also where this smash and grab originated? If you steal stuff that's $950 or less, it's now only a misdemeanor.
Prop 47 eliminated as a felony the crime of petty theft with a prior. It screwed up the definition of auto burglary, which has certainly contributed to San Francisco's epidemic of auto burglary. It reduced the amount that had to be stolen in order for it to be a felony from it increased the amount from 400 to 950, and the criminals are well aware of the amounts they can take. And I think that the general sense of they're not really going to prosecute me anyway, so I'm just the criminals were emboldened,
Right.
and you can see it on videos all the time. One or two individuals walk in with their little shopping bag full of stuff, walk out undeterred, very rarely confronted by security, certainly very rarely confronted by law enforcement.
Well, it seems like to me it just has a pernicious effect on people who want to be law-abiding citizens. Because, say, for example, if my children are adults now, but if I had a young child with me and I was in a store and somebody grabbed stuff, stole it, and walked out, and they're not being stopped, and my child looked at me and said, "Dad, why isn't he being stopped and arrested?"
Something tells me your child would be a moral person who would be offended by the crime that they just observed happening.
I think they would, but that a child today may look to mom or dad and say, well, if that person's not being stopped, why shouldn't I do it? Who cares about the laws?
It certainly undermines the goal of deterrence of the criminal justice
and respect
system.
for the law.
If people aren't arrested, and the respect for the law,
Right.
for starters, which leads to them, certain individuals being emboldened to commit those crimes. And look at San Francisco.
Yeah.
It's not just people being emboldened and lack of deterrence. Up there you have retail establishments shutting their doors. Nordstrom's, sort of a high-end retail outfit, they're shut down in San Francisco. They used to be on Union Square, one of the premier places for people to go shopping. They've shut down. I think Bloomingdale shut down. The drugstores, they're shutting down right and left in San Francisco. They're in a because they can't afford it. It's such a loss. It's not worth being in business when you're losing money all the time and putting your employees at risk. So they close their doors.
It's almost an indirect tax on law-abiding citizens, isn't
Yeah.
it? So they're paying the penalty of not having access to these stores.
Well, yeah, and then the sales taxes that would have been generated by those stores, those are no longer in the public coffers to deal with some of the problems that are out there, especially in San Francisco, with all of their problems, which are myriad.